One of the many cases the Supreme Court is set to hear this term, or was supposed to hear, but now maybe won't, at least on the merits as we'll get to, is a case out of Idaho involving a transgender athlete who wanted to run cross-country at Boise State University. New Idaho law says, sorry, only women in women's sports, and this transgender runner says he has a constitutional and statutory right to run like a girl, actually. We've seen variations of this dispute across almost all levels of athletics for years now, so presumably we are headed toward some sort of resolution on what laws states can pass to handle the matter without kooky court injunctions blocking them. That's all expected. But what was not expected, at least by me, is the procedural oddity this case has become, because after years of trying to block enforcement with the ultimate goal of getting this law struck down, now, on the eve of a final Supreme Court answer on this issue, the transgender runner who brought this case now says, just kidding, guys, I don't actually care. Let's just not do this lawsuit anymore. And the courts, potentially all the way up to the Supreme Court, aren't letting him out of it. Sorry, you brought this case. Now you're going to finish it. Now, I'm no lawyer, so I'm sure stuff like this does happen. I just haven't heard of such a situation before. Someone filing a lawsuit to try to overturn a law, then deciding they don't want to do it anymore, but the court's compelling the case to continue on that person's behalf, or at least to resolve his dispute. It's a very interesting development. Anyway, intrigue aside, the facts of this case date back to 2020. On the eve of COVID world, the Idaho legislature passed and the governor signed the Fairness in Women's Sports Act. Now, there's a lot of detail to this law, but its basic function is straightforward. If you were born male, you cannot play in women's sports. Now, of potential legal relevance later is the fact that the law only says no men in women's sports. It does not say no women in men's sports, though, as a practical matter, that sort of thing almost never happens. Anyway, I'm not even sure I've ever seen one example, actually. Enter our transgender athlete to challenge that law with a name I can't even believe is real or serious. Lindsay Hecox was a freshman student at Boise State at the time of the law's passage, and Cox wanted to run women's cross country at the university. And yes, everyone's thinking the obvious joke, more like Lindsay Shecox. Am I right? You are right, which is why he has to change his name. This cannot be taken seriously. If you want us all to believe you are actually a woman, you gotta go all in and become Lindsay She-Vagina. But Lindsay Hecox filed a federal lawsuit in Idaho, arguing the law violates the Constitution's equal protection, due process, and search and seizure clauses. More on the constitutional arguments later, as well as Title IX, the federal law that prohibits sex discrimination in education. So yes, this guy is arguing that it's not discriminatory against women for him to compete athletically against them. It's discriminatory against him to be blocked from doing that, actually, as though the intent of Title IX's passage was men taking women's opportunity and not women's opportunity away from exactly that. Beyond the contrived legal complexity, there isn't any. There's also been contrived biological complexity, with the propagandists hard at work spinning the case that Lindsay Hecox has no inherent advantage running against women. Vice News profiled Hecox in 2020, acting like this is some mixed bag of scientific mystery. Well, sure, there are some advantages, but there are some disadvantages too, so really it all just kind of evens out.
Joanna Harper, a longtime competitive runner, is one of the few researchers who has dedicated her career to studying the effects of hormone therapy on transgender athletes, like herself.
Is there any validity to the concerns that people have expressed about transgender women having a greater physical advantage on the field?
There are advantages that they would have. Longer legs, bigger chest capacity, those sorts of things are all advantages, but disadvantages too, and particularly with running. And so while trans women have advantages, there's no evidence that trans women have overwhelming advantages.
Well, hey, big thanks to the corpse of Kathy Griffin for taking time away from the coffin to simplify these very difficult concepts for the rest of us laymen to understand. As though that guy has no particular interest in validating whatever it is he's done to himself. Because I noticed he listed several specific advantages, and then just said there are disadvantages too without actually naming any. It really is amazing how the one thing that the science can't explain lately is the difference between men and women, probably the most basic scientific observation that our species has understood since before we could even write to produce a study about it. And of course, the argument is then contradicted in the very same news piece by the transgender athlete. Well, I can't compete with men. They have superior natural traits.
As the law stands, Hecox can still compete, but only on the men's team.
I would not only be outclassed, but I'd be humiliated if I was competing against cis men. I don't look like a man. I don't have the competition levels or just the testosterone levels to compete with cis men. And so why would you force us to be in the disadvantaged group?
But I guess maybe Tales from the Crypt Kathy is actually right. Lindsay Hecox didn't have an inherent advantage. Either that or he sucked so bad despite it that the advantage didn't even matter anyway. Vice's characterization says Lindsay Hecox was set to be on the women's running team at Boise State, but that was the 2020 COVID year, so the cross-country season was canceled. And if Hecox was going to be on the team, it's very odd that he couldn't make the team in the following years. That fall, after the law passed 2020, Hecox tried out for women's track and cross country at Boise State and did not make either team. He then took a leave of absence from the school to train to try to make the teams later, and that plan got a little delayed. Hecox didn't re-enroll until January 2022, intending to try out for the teams again in the fall of that year. He actually never did that either, and instead played women's club soccer, which doesn't require tryouts, as in anybody who wants to play can play. Now, why couldn't Hecox stick to the plan of making the women's running teams? Well, it's not that he was bad at running or actually was never even serious about any of this at all. No. He got COVID once, and he didn't want to be irresponsible by exposing the team. Not sure why it was fine to expose the soccer team to COVID, though. And how was Hecox able to continue this charade of playing women's soccer and acting like he was one day going to make the women's running teams while never actually trying? It's because that initial court challenge from the spring of 2020 secured an injunction against the law, a block on enforcing it. So Lindsay Hecox has been free to swing his hecock in races with girls, or to try to or not try to ever since. And so has any other transgender athlete in Idaho, and presumably any other state or locality in the Ninth Circuit that enacts a similar law. But while enforcement has been on hold, Idaho and the state's attorney general have been appealing the case, now all the way to the Supreme Court. And in July, the Supreme Court said, yes, we will hear that case in the upcoming term. Well, now it is term time, and Lindsay apparently changes his mind even more than his Hecox. Not only does he not want to run on the women's cross-country team that he couldn't make anyway, not only could he not stick to a plan for when that would ever even happen, but now for the entire court case itself, he just says, just kidding. No, thank you. In September, Lindsay Hecox and his lawyers at the ACLU filed a motion to dismiss the case. He says he doesn't want the negative public scrutiny anymore. There is increasing intolerance for transgender people, and he just wants to be left alone now. And he's made the extremely difficult decision to stop participating in women's sports. So this case is moot now. Sorry for wasting your time, but everybody can go home. And maybe he has changed his mind. That is a thing you can change, after all, and often should. His mind, in this case, included. However, this move creates a very convenient circumstance because cynically, it sure looks a lot like Hecox just used the court system for temporary personal benefit and is now bailing when it's no longer of personal use. Hey, no enforcing that law while I'm in college, but now that I'm gone, don't care anymore. And that could be fine for something that is just a personal dispute, but this is not. Hecox and her lawyers have stopped the state of Idaho from enforcing its law at all on anyone for 5 years now. That has to be resolved. Plus, other states are waiting too. The Supreme Court has agreed to establish some national standards on this issue. They're just standards that Lindsay and his lawyer probably won't like much. Again, hence the probable strategy. Hey, maybe if we just quit, the Supreme Court won't even rule at all. So in something that sure seems unusual to me, but lawyers can tell me how common this is or not, The district court judge on the case, David Nye in Idaho, he says, no, we are not dismissing this case. Too bad. This really looks like a manipulative attempt to deny the state of Idaho the resolution at the Supreme Court to which they are entitled after years of legal proceedings now. So how does this actually work now when you're effectively forced to continue a lawsuit you don't even want anymore? Honestly, I'm not even sure. But from what I can see, since the Supreme Court has already agreed to take this case, they'll have to rule themselves on whether the case is now moot. The district court judge says no, it is not, insofar as the state of Idaho and the will of the people there have been delayed for years. They need resolution on their law. We'll see if the Supreme Court agrees, and if so, they'll move to the substance or merits of the case. Even if they don't agree and the court says this particular case is moot, it's not like the issue is going away. The Supreme Court will have to resolve this matter anyway, because most states have some version of a law to this effect now. No men in women's sports. It's at least 27, and several of those state laws are still tied up in the courts. So the Supreme Court will have to address all the legal arguments holding these cases up, all of which are bunk. In the Lindsay Hecox case, he has several. He says the law violates the Equal Protection Clause of the 14th Amendment that generally prohibits sex discrimination. Well, one, this law protects against sex discrimination, actually. It preserves female spaces and activities away from male intrusion. And two, for any argument that it's unconstitutionally enforced one way, as in it only bans men from women's sports, well, that's not necessarily unconstitutional. With gender discrimination claims under the Equal Protection Clause, the court applies what's known as the intermediate scrutiny test. It's not as though all gender distinctions are unconstitutional. Many, if not most of these distinctions exist for very good reason and are constant throughout our history. So Idaho just has to show that they have an important government interest furthered by means substantially related to that interest. And protecting women's opportunity in education is the important government interest of Title IX itself. So there's two birds, one stone with just that argument alone. This law is compliance with the federal Constitution and statute. It is not defiance of it. Lindsay Hecox also has an appeal to the do-all due process clause of the 14th Amendment, the one magically interpreted to protect the supposed constitutional rights to everything progressives love: abortion, gay sex, gay marriage, the list goes on. And likewise, the idea that the intent of the ratification of the 14th Amendment after the Civil War was men running against women on the university track is preposterous and ahistorical. So this too is squarely a state's issue to regulate, like anything else. The logic would be the same that the court has applied to restrict or undo other supposed substantive due process rights. If it ain't in the text or a clear part of our history, the issue belongs to the states. Now, all of this potentially creates a very entertaining day at the court where not only do we get to hear insane arguments, ironically from female justices, for whatever reason they can manufacture to explain why the supposed right of a man to compete athletically against a woman isn't just sensible, it's constitutionally protected. Not only do we get that show, but Hecox's ACLU lawyers will be compelled to be there to do it too, against their own wishes and those of their client. They know they're going to lose. They know they'll look like clowns. And the person for whom they're clowning doesn't even want them to clown anymore anyway. But it is either that or forfeit the case effectively. And the court will allow Idaho and the rest of these states to move forward with their laws. These ACLU lawyers will look like idiots or cowards. And they'll almost certainly come up with some way to do both. And if they do take the path of their client and just quit, if these ACLU lawyers decide they don't want to participate anymore either, how does that even work? Would the Supreme Court just hear one side's argument? Would there even be a hearing at all? Maybe something like that has happened historically. I'm just not aware of it. But I hope they will show up for their day in court. As confused with their reason for being there as they are with their terrible legal arguments, it will be on brand for them. Because since when has the ACLU walked away from an opportunity at tortured logic in the name of air quotes freedom at the expense of actual freedom? It's been decades now. This is their operation. They have to follow through. Besides, if you worry it'll look foolish to argue on your own behalf under these strange circumstances, just imagine how foolish it'll look if Sonia Sotomayor and Ketanji Brown Jackson are making the argument for you. That'll be even more embarrassing. So I know it is very tough to make the prestigious Boise State women's cross country team as a man. But don't get discouraged and keep aiming high, because you never know what you could achieve if you try. After all, somehow those two made it onto the Supreme Court. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on X. That is at ML Christiansen. You're always welcome to coming out and chat my live streams as live on Wednesday and Sunday nights. Looking forward to it. Goodbye.